I just want to first apologize to you and the course for coming in here intoxicated. And when I went to jail the other day on the 11th, when I told the police officer what I did, he said, you was better off not even coming to court.
On the record in state of Michigan versus Deshaun Fifield. Our case number is 2201621FD, and I believe the circuit court case number is 22548FH.
Morning, Your Honor. Cassidy Kachukas for the people.
Assistant Public Defender Joseph Hardy on behalf of Mr. Fifield, who was standing to my left.
Firstly, Mr. Fifield, are you wearing a scram tether today?
Yes.
That's important because I need to know you're sober so we can have this conversation.
Yes, ma'am. Understood.
So before we begin with arraigning you on your new alleged violations, I need to know whether you understood what you did last week.
Yes, I do.
You appeared in my court in a condition and I proceeded to take a plea to probation violations and sentence you. So I need to make sure that you understand. Last week when I saw you, you pled guilty to, let me make sure I get the right show cause in front of me. You pled guilty to, not the right one. Sorry, there's been several papers added to your files. I gotta find everything. Failure to test on September 3rd, all the way up through September 18. You remember that? That you pled guilty to failure to provide your urine screens between September 3rd and September 18?
Yes, I do.
Okay. And you also pled guilty to failing to report to your probation agent on or about September 13. September 16. You remember that?
Yes, Your Honor.
And so after you entered that plea, I sentenced you to 7 days in jail with an order to enroll in outpatient treatment, as you told me you weren't actually in treatment at that time, and an order to wear a scram tether for 60 days. You remember that?
Yes, ma'am.
Today, you're before the court for a new petition for probation violation. You must remember that if you violate probation, you face up to 5 years in prison upon probation revocation. You have the right to have an attorney. If you can't afford one, we see if the public defender will represent you. And I think since they're already sort of engaged, they'll probably just keep going.
Yep.
You have the right to have a hearing where it must be proven by a preponderance of the evidence that you violated the terms of your probation. The alleged violations today are, I'll try to get the right paper in front of me this time. That on or about October 11, you admitted consumption of alcohol, which would be a non-technical violation. You understand that?
Yes, ma'am.
And the other allegation is that on or about October 11, 2024, you consumed alcohol and provided a positive preliminary breath test result of 0.194, again, a non-technical violation. You understand the possible penalties of violating probation?
Yes, Your Honor.
You understand the alleged violation?
Yes, ma'am.
Mr. Hardy, are we setting this for a hearing?
At this point, Mr. Fifield would like to admit violations. I don't think that a hearing will be necessary.
Mr. Fifield, you understand the, if you choose to go forward with pleading guilty to probation violation, you give up your right to have a hearing on whether you did violate.
Yes, Your Honor.
And you understand that I've told you that if you chose to have a hearing, they'd have to prove by a preponderance of the evidence that you violated.
Yes, Your Honor.
You understand that we've provided you with assigned counsel.
Yes, Your Honor.
You understand that I've already informed you that there is a consequence to this, wherein if you plead guilty to these violations or are found guilty of these violations, you may be revoked from probation and go to prison for 5 years.
Yes, Your Honor.
And you're wishing to proceed with a guilty plea.
Yes, Your Honor.
Raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth under penalty of perjury?
Yes, Your Honor.
Mr. Fifield, it's true that you have been on a probationary term ever since you were revoked from specialty court back in May of 2024.
Yes, Your Honor.
It is a condition of your probation term, condition number 2, that you not consume any alcohol. You remember that?
Yes, Your Honor.
I saw you in court on October 11 for a probation violation hearing. Is it true that after our hearing on October 11, when you were going down to the jail, you admitted that you had consumed alcohol on October 11?
Yes, Your Honor.
Is it also true that you tested positive for the consumption of alcohol on the preliminary breath test?
Yes, Your Honor.
And that's because you did in fact consume alcohol that day.
Yes, Your Honor.
Did anyone make any promises or threats to you in order to get you to plead guilty here today?
Yes, Your Honor.
Are you pleading guilty of your own free choice?
Yes, Your Honor.
I find your guilty plea to be knowingly, voluntarily, accurately made with sufficient facts on the record upon which to base your plea, therefore accepted. And I think I have to characterize that as really one non-technical violation, because it's really the consumption of alcohol which resulted in the omission in the text. Let me ask this, Agent, Ms. Parker, you better be still. You would not be up walking around in my court. Agent DeRose, did you want to make your recommendation orally today, or did you want me to give a sentencing so you can prepare something more formal?
I can provide it orally, Your Honor.
Okay, if you would like, I'll let you get the microphone there.
Mr. Fifield has been on probation with me for a few months now. When he was originally sent over, he was on a scram tether. He seemed to do great with his tether, no violations. He had an attitude of he was ready to get some help and move forward. Once that tether was taken off, that's when he started to struggle again. When we were here before court, obviously he still, absconded, continued to drink. And then, showing up to court that way. Speaking with the defendant this morning before court, I know he has mentioned he wants additional help. He's acknowledged that he needs additional help. However, given all the help he's had through sobriety court, and now with probation and 30th Circuit Court, I don't know that another residential would be suitable for him. Already completing House of Commons twice successfully. So I don't know that that would be the best option at this time, given the non-technical violation and all of his past violations. I would recommend that he be sentenced to 180 days jail with credit for 40 days served and his probation be revoked.
Ms. Kachukas, do the people wish to be heard on sentence for this defendant?
No, Your Honor, just that those recommendations be followed.
Mr. Hardy?
Thank you, Your Honor. Mr. Fifield, someone who suffers from alcoholism and substance dependence, he knows this. He knows that the choice that he made, last week, was ill-advised, to say the least. But he's someone that wants to do better, wants to get sober. He was not showing that. He had explained to myself that in addition to the nervousness from him going to jail, he was afraid of getting the shakes and sweating. That's how deep this dependence goes. I do not believe that Joe would serve him well. I think that what he needs is residential treatment. I understand that it's been multiple times doing so, but I do believe that this that last week and continuing into this week, is a wake-up call for his behavior. He knows that this type of behavior puts himself and those that he loves in jeopardy, and I believe that he would benefit from another stint with residential. He's told you and told myself that he likes to scram tether to keep him honest. And I think that's just a matter of getting his body and his mind to a point where he doesn't need it. So at this point, we would just be requesting that he be allowed to attend residential as opposed to jail time, and that his probation not be revoked, Your Honor.
Mr. Fifield?
I just want to first apologize to you and the course for coming in here intoxicated. And when I went to jail the other day on the 11th, when I told the police officer what I did, he said, you was better off not even coming to court. And I was like thinking to myself, why would I abscond and then turn myself in? He said, she probably would have just gave you the same time that you got instead of come back in here intoxicated. And I was thinking to myself, I don't think she would do that. But get back to today, where I'm at and the help that I need. Jail time, yeah, I'm gonna sit there, I'm gonna think about what I did and how can I fix it. But treatment is gonna help me sharpen my tools back to get back where I need to be in life. And I would like to stay on probation, but also I appreciate all the work that you have tried to help me get better and give me so many tries. I appreciate that, but at the same time, I need help. In jail, all I'm gonna do is sit there and think about what happened, but it's not gonna get me better to be where I need to be at in life. That's all, Your Honor.
As I had outlined when I saw you just 1 week ago, you were in a treatment court program for a good period of time. This is not a case wherein, Mr. Fifield, we began with you in May of 2024. We actually began with you in August of 2022. And we did put you in House of Commons twice. You successfully completed each time, but you had many, many violations. And in review of the file for this week, it's clear that I followed the specialty court goals in not giving you jail when those things were happening and repeatedly offering you rehabilitation over and over again until it was clear that the ultimate violation that caused you to be taken out of specialty court was not for substance use, but instead an intentional decision on your part to continue to violate the law. And now here we are today on probation, and we have continued decisions wherein, Mr. Fifield, you said you went to treatment before court on October 11. And yet when you got out of that detox, you resumed consumption. You argued to the court that you have your wife as a support who will help keep you accountable. She brought you to court intoxicated, not a little intoxicated, a lot intoxicated. So considering the snow factors, firstly, reformation of the offender, the court has made efforts of over 2 years to reform Mr. Fifield and give him all the treatment options that were possible, sending him to residential treatment, intensive outpatient treatment, scram tether, continuing supports of from the courts and from treatment providers, and it has not worked. For protection of society, I have concerns about Mr. Fifield's continued decisions to drink and also continued decisions to intentionally drive without a license, as he did twice during his specialty court participation. Third, disciplining of the wrongdoer. Mr. Fifield, I told you last week, and I'll tell you again, each time that you have gone to a treatment program, it has been during a time where you perceive that the alternative was jail, and it is time for you to have consequences for the same decision occurring over and over again. And lastly, deterrence of others from committing a like offense. This is an OWI third offense for which you have repeatedly consumed on probation and on bond, and made other decisions that included violations of the law. Based on all of that, I'm revoking your probation, and I think your guidelines were 0 to 6. And that is the reason that I will give you the 180 days with credit for 40, because I'm gonna stick to the guidelines today. Mr. Fifield, you have some soul searching to do, because if you come before a court on an OWI third offense that is really your fourth, and you behave in this way, I have no doubt your guidelines will be higher and you will be facing much more significant consequences. If you would like to appeal my sentence and you need a public defender to assist you, you need to make your application for a public defender within 21 days and file your application for appeal within 42 days. You have questions?
No, Your Honor.
I really do hope that this is the final turning point for you, because you really precedent. If you hurt somebody, you're going to prison.
Understand, Your Honor.
Best of luck. Anything else from the lawyers?
Nothing further, Your Honor.
No, Your Honor.
Thank you. All right. Guess we need to see Oscar next. Thank you, Mr. Rose. Have a good day.
You too.